Hi, welcome to this program. My name is Bhagwat. I am a professor of law at the University of California at Davis School of Law. And we are here to discuss a paper titled Online Account Termination, Content Removals, and the Benefits of Internet Services Enforcing Their House Rules by Eric Goldman and Jess Meier. Eric is a professor at the Santa Clara School of Law. Jess is a former student of Eric's at Santa Clara, but is also currently an attorney at Google, but she is going to be here in her academic, not her Google capacity, I should emphasize. Just one word, that the article was published in the first issue of the Journal of Free Speech Law, which is a new faculty-edited free speech journal that Eugene Volokh and a couple of us have founded. The theory behind the journal is that it'll be faculty-edited, faculty moderated. We will be selecting articles, we'll be publishing regularly, and we will be publishing quickly on any topic of free expression interest. If you are interested in submitting, please check out our website. And with that, I think I'm going to turn it over to Eric and Jess to present their paper, and then we'll start a conversation.
Okay, I was not letting me off mute. I apologize. Just a quick clarification. Thank you so much for having us, by the way. Super excited to present the paper. One quick clarification. I am not an attorney at Google. I do public policy for Google. I might be an attorney, though. We'll see. The bar results come out this Friday. So
my apologies.
No, totally good. Fingers crossed. So with that, I'm going to go ahead and share some slides. So give me 1 second to set that up. Okay. And can everybody see the slides? All good? Excellent. Okay, so yes, we're going to be presenting about our paper, The Benefits of Internet Services Enforcing Their House Rules. This is a paper I'm particularly excited about. As a student, as a 3L, I had the opportunity to work with Professor Goldman on this project. It was really cool to have a publication under my belt, before I graduated. So this one is definitely special to me. In the slides, which we will send over as well for everyone to see, we've got our link to our paper too. So how did we kind of start out with this project? We started from the premise that, most media enterprises, offline traditional publishers, adopt house rules or editorial standards for making decisions about content that they choose to publish that is, might as well be constitutionally protected, so 1A protected, but may not be suitable for the publisher's audience. And so we kind of, thinking about this in terms of internet services are publishers in that regard. They disseminate our information to the public. Internet services adopt similar house rules about the content that they choose to disseminate to their audiences as well. However, going off of that, there's a lot of folks, regulators, plaintiffs included, that would like to see this kind of go the other way for internet services, in that internet services should not be able to set sort of these rules of the roads or standards for the content that they choose to decide to publish to their audiences. Some examples of these ways in which they would want to restrict internet services are in the form of what we call must-carry obligations. This is the idea, internet services should be treated differently from their traditional offline counterparts in that they are common carriers or utilities. And if they are common carriers or utilities, they would be required to carry all content that would be considered constitutionally acceptable, regardless of whether that content is suitable for their audiences or not, or if they go against the service's house rules. So we've seen some examples of these bills over the past several years, really since 2019, at least from the federal government, with ideas to propose amendments to laws like Section 230, or lawsuits that would kind of hold internet services liable either as state actors or, again, as this common carrier approach. And we've also seen two recent examples where the states are sort of entering this conversation and trying to come up with similar proposed regulations. So one example would be out of Florida. Just recently, there was a regulation that would propose that internet services have to be consistent or neutral about the ways in which they make their editorial decisions. And in Texas currently, there's a bill that states that internet services would need to be viewpoint neutral with regards to their editorial decisions. So again, this is the idea of, if internet services are going to set these house rules, They need to be incredibly neutral or consistent with the way that they apply those house rules, or internet services shouldn't have those house rules at all. They should just, be required to hold only First Amendment protected content, again, whether it goes against what their audiences want to see or not.
And Jess, I'm sorry if I can just chime in. Laws that require consistency or viewpoint neutrality really are backdoor must carry rules, because it's impossible to moderate content consistently. There's no real way to do that. And so in order to manage that responsibility, the services have to be over-inclusive in what they think it means, and they're still going to make mistakes. Or this idea about viewpoint neutrality. I don't know what a viewpoint is in this context, but it's almost impossible to have any conversation about anything without someone saying, there's another viewpoint on this that I want to advance. You must carry my viewpoint now if you're going to remain neutral, or avoid discriminating between these viewpoints. So they don't use the words must carry, but there's no doubt that they reach the same conclusion.
Absolutely. We'll get into some of the effects of what must carry would look like if it was actually practically applied. So going off of this sort of premise, internet services, they're publishers, they set house rules. Our paper sort of looks at two questions. So the first one is, what have the courts said about internet services? So do internet services have sort of the constitutional freedom to engage in editorial discretion, to apply their house rules to content that may not be acceptable for their audiences? And the second one is, what would happen if it were, if this were to change? So if these must carry rules were to become the status quo. So what we did to kind of tackle these two questions, we created a data set of 62 cases, all of which where internet services were applying their house rules. And what we mean by that is, they were either terminating accounts or removing or downgrading content that, did not meet those house rules or did not match their audiences. As you can imagine, there have been a lot of lawsuits around how internet services apply their house rules. So we set a cutoff for March 15th. So a lot of the former President Donald Trump's cases against Facebook and Twitter and YouTube, they would be in scope of this project, but they are beyond that cutoff date. And some of the plaintiffs that we saw that kind of appeared in these data sets include Parler, folks like Tulsi Gabbard and Laura Loomer, Jared Taylor, and of course, PragerU. So what are plaintiffs pleading in these cases? That's what we were primarily interested in diving into. So a lot of the claims had to do with stuff such as, the service is engaging in what they claim is unconstitutional censorship. And that gets back to my point of this idea that plaintiffs want to hold internet services as state actors. If they are state actors, then they cannot remove constitutionally protected speech from their services. So that one comes up regularly. We also saw, and as Professor Goldman will discuss in the next slide, we saw several claims that have to do with illegal discrimination. So a lot of those types of complaints really had to do with, folks that were sort of using their majority attributes to complain about their, removal of their accounts or their content. So, we saw things such as folks that were saying they're being discriminated against because they were heterosexual, for example, or that they were Christian. Some other claims, we saw some breach of contract, consumer protection related claims, and then, a variety of other claims as well. But I think the majority of it is based in this, the internet service unconstitutionally biased, took an unconstitutional biased action against the plaintiff with regards to their content, whether that be downgrading, demonetizing, or account blocking, for example. So some of the things that we found, interestingly, so, and I would say almost unsurprisingly, the defendant internet services, they win early and they win often, right? Because they have so many tools to use in order to sort of get to those conclusions. For the most part, what I found kind of surprising or interesting, Section 230 probably mattered the least. It was the least necessary tool in that toolkit for their defense wins. Rather, the way they were winning these cases, it was either because several of the cases came in as pro se. So of course, those ones, you're not represented by an attorney. Those ones you're more likely to lose at the outset. But also the claims that the plaintiffs were making were just they were flawed at the beginning. So they, none of these plaintiffs were actually winning on the final merits there of their cases. So sort of we reached this conclusion after looking through these 62 cases that internet services indeed do have the constitutional right to have unrestricted legal, unrestricted freedom to engage in editorial discretion. They have the right to be able to set their house rules and apply them the way that they see fit for their specific audiences. Professor Goldman, I'm going to throw this back over to you. You're on mute.
Yeah, thank you. And I just want to add one more point about this fact that the pro se cases are overrepresented. So roughly half of the cases in our data set were pro se cases. And of course, they're not likely to win. That's not surprising. The pro ses have a huge challenge, especially when they're going up against giants. So, the deck is stacked against them. But to me, it's really kind of an indicator of what we're going to see if there is a private right of action that is enabled to enforce a consistent, to enforce the provisions that content moderations decisions must be made consistently or viewpoint neutral. There's just plaintiffs just chomping at the bit to do this. I really don't think the court system's prepared for the kind of flood of litigation that's likely to occur. Some of that will be, in fact, represented if there's enough money on the table. Lawyers will take those cases. But even without that, basically, every time someone's unhappy with the content moderation decision, we're going to see them having the opportunity to go to the courthouse. And we should note, of course, then there's going to be a lot of cases that would, I think, really overwhelm any kind of scale of litigation that we're used to seeing. Can we go to the next slide, please? All right, so the first half of our paper does the descriptive analysis of what we're seeing in the courts. Just to reinforce what Jess had said, we try to be as comprehensive as possible. It's possible we missed some cases. I hope we didn't. But we tried to find every case that we could that related to an account termination or a content downgrade or removal that led to an opinion that we could find. We tried to put them all in. So based on that descriptive status, we could make the claim that Jess mentioned at the end. We think that there's the law protects internet services exercising control over their house rules without creating legal liability. So the next step is that a good idea? And what I think baffles me, and I'm only going to speak for me here, not for Jess, is how many people think that's not a good deal. And I don't understand what world they think they're going to live in if we were to change this rule. So what we tried to do is lay out how that looks if the internet services no longer have the right to enforce their house rules. Now, under that circumstance, we think that they would still be required to remove illegal content and stop illegal activity, though things like the Florida law don't actually say that. So they expect, they don't make it clear what they actually want internet service to do if they're dealing with illegal content. But the rule would be, if we were to have a must-carry obligation, we assume that illegal content must be removed, but legal content cannot be removed. It's simply not in the internet service's discretion anymore whether or not to remove it. As I said, things like consistency or viewpoint neutral application of content moderation leads to the same basic premise. I don't think it actually leads to any different outcome. And so what we did was we modeled what are the policy outcomes that we would expect in that circumstance. And just to preview, they're terrible. These are like really bad outcomes, in my opinion. This is why I'm so baffled by seeing so many people think this is the world they want, because we think this is the world no one should want. So the first outcome that we think is possible is that it could turn into a free-for-all. The content, the spammers and trolls take over. And there's nothing that internet services can do about them because the spammers and trolls are posting legal content. It's just really not what anyone wants. And so what happens in that circumstance is that the bad content is going to drive away all good discussion. And everyone knows this. You cannot be on a message board or even on many email lists without having someone who's moderating that content. If you don't have someone who's cleaning it up, you know that conversation just devolves into a situation where nobody really wants to use that speech venue anymore. And we had so many examples of people who were suing for the right to force the internet services to carry their spam, to carry the promotion of dangerous substances, to carry misinformation or disinformation, These are the things that the lawsuits were trying to require the internet services to carry. And so what does the world look like when that kind of content has no break on it? There's no suppression of that kind of content. We know that I'm not going to hang out in a place that's dominated by spam and misinformation. And so are most of you. You're likely to get the heck out. And in that circumstance, then the bad content drives away the good. And I will also point out that there's many ways in which the content that people were suing to require carriage would exclude people and drive them away, not just because it's bad content, but because it made them feel like they're not part of the community, or targeted them based on their personal attributes. So we saw lawsuits that said, I want the right to disseminate my hate speech. I want to speak out against LGBTQ folks, or I want to engage in racial slurs, or I want to misgender or dead name trans people. So these are the kinds of content that currently we hope and expect internet services are taking out, so that people who have those attributes are not felt like they're unwelcome in this community, but take away the ability to remove that content. And of course, then the people who are targeted say, this is not the place for me, I'm out. So what happens when the bad content dominates the good content is that it's not monetizable. There's just no way to turn that into cash for the service operator. They can't run ads against it. And there's been many efforts by advertisers to increase what they call brand safety of where their ads are showing up. They don't want to be associated with the bad content. They don't want to pay to fund the bad content. And so they're just opting out of those advertising venues. There's no way to set up a paywall around the services that have been overtaken by the bad content. Who's going to pay for that? Nobody wants it because it doesn't solve any problem. So if you can't monetize it through ads, you can't monetize it through a paywall, what's left? There's no economic business model. And most importantly, we should recognize that what we're really saying when we say we want to let everyone have a voice is we want to reify the existing power structures. And so there's a really interesting equity question here. What happens if you don't take efforts to protect the minority voices from being overwhelmed by the majority voices? Well, the majority voices are going to say, we want to continue to have the majority status, and we're going to demand that. And so we've seen lawsuits where Christians and males and heterosexuals said, you remove my content because I'm a Christian, because I'm a male, because I'm a heterosexual. You've discriminated against me based on these protected attributes. And so the majority players who share those attributes are going to use and weaponize any legal rule to ensure that they retain their majority status. So it really is going to be a situation where not only will people feel excluded because they're going to be targeted, but they're going to be excluded because of the fact that any time that a minority interest gets extra attention or visibility, the majority are going to say, you don't deserve that because you're discriminating against me based on my protected attributes. Okay, so possible outcome number one is I put it as a possible outcome, but I don't think it's really possible. I don't see a world in which that actually can be the internet that we use and enjoy. So I think the more likely possible outcome is a shutdown, which is really odd because the idea is that the regulators and perhaps the plaintiff think if we can just force internet services to carry our content, then we'll have more speech. But actually what we're likely to see is less speech because there will be fewer speech venues in which people will be willing to talk because they can't crack the nut of the things like the business model. Now, a third outcome is to say the big services won't shut down. There's too much money at stake for them to shut down. They're not going to just walk away from this. Instead, what they're going to do is I think they're going to shift away from amateur content to professionally produced content. So what that means in practice is they're going to say, we're not going to let you and I talk to each other. We're not going to have a conversation online. We're only going to let the people who have existing power and privilege, we're going to turn over the keys to them in order to let them get a voice. So in order to fund professionally produced content, paywalls are almost certainly going to be required. So, today we assume that we can find lots of free information on the internet, and we could just imagine a world in which these paywalls just get thrown up left and right. All of a sudden now we're not able to access the things that we used to think we could get for free. So that's just going to cost us money. This is going to come out of our pockets. In order to enjoy the content on the net, we're going to pay more than we currently do today. And that has distributional effects. That means the people who don't have that money are going to be frozen out of the internet. The things that they're getting for free, they can't get for free anymore, which means that they're not going to be able to afford to participate in the digital ecosystem. If we move away from amateur voices to professional voices, that means fewer voices are going to be represented. There's only going to be a certain amount of content producers who are monetizable, who will have enough value to be worth paying for. It means that the people who are otherwise going to be not monetizable, they just won't get a voice whatsoever. And of course, that means that less diverse voices are going to be represented because of the fact that they're going to be shut down from being able to speak. They're going to need to get through the gatekeepers, and the gatekeepers, like the existing power structures, are going to continue to reinforce the majority interest as opposed to the minority interest. And so I think in this third outcome, we're just going to have fewer speech venues, and we're going to have more Quibbies. I know Quibi is like a bad joke, but it's actually really illustrative here. If you remember, Quibi was designed to be a mobile-friendly short video site that was paywall. Nobody wanted that. That's why it's out of business. And yet the legal rule would drive us towards seeing more Quibi type content and less of the things that we actually expect to use today. Okay, so our paper lays out both the descriptive piece and the normative piece. Thank you so much for letting us give it a chance to preview it, and Ash, will turn back over to you to see how you want to take the conversation.
Thank you to both of you. So I'm going to encourage people in the audience to ask questions at some point as well. For now, I had a couple of questions for you that intrigued me, because I was curious about what you guys, and this is for both of you, what you guys saw in the cases. Like, first of all, what kind of, would be interested in a little bit of detail on what kind of content people were trying to post, like some examples. And also, like, why, in particular, why the contract claims that the service was not following its own rules, why did those fail? Because I find your results striking. The fact that I assume the services would usually win, but the fact that they always win, that's unusual.
Jess, do you want to talk about the kind of content that we saw that people were suing over? I mentioned some of that in my remarks, but go ahead and do you want to fill in some more details? You're still on mute, Jess. Oh, there you are. I think you came off.
I don't know why it's doing that. Yeah, absolutely. So, you know, like I said, we kind of addressed some of the different concerns in the presentation, but to kind of drill into it, you know, some of the cases that really stood out to me, one of them had to do with dead naming transgender folks on Twitter. I believe that was the Murphy case, the Murphy v. Twitter case. So that was one where it kind of gets to the discussion of, you know, somebody who would usually be sort of in the marginalized community is, you know, suffering from the effects of having somebody misgender or dead name them purposefully on the internet. And as, you know, our paper sort of gets into some of the results of you know, or some of the consequences of when you are dead named or misgendered, it can have some serious psychological, mental health related concerns and also physical concerns as well. So, you know, that was one that sort of stood out to me. I think another one was the Doman case, where I believe that was a discussion about, or that case was about videos that had to do with LGBTQ conversion therapy. Again, similar results or similar possible consequences as the dead naming and misgendering, that can result in a lot of serious mental health sort of effects as well. And then another one that's sort of top of mind for me was actually the Enhanced Athlete v. Google case, and that was that involved videos that were promoting sort of dangerous, FDA stated dangerous supplements and products similar to steroids for fitness and health. And again, stuff that could be incredibly physically detrimental to folks if they were to use those supplements based on the videos that they were seeing. So that's a few. I'll leave Professor Goldman to speak to some of the contracts related claims.
Yeah, so the contract claims failed on a number of different grounds. First, sometimes the plaintiffs tried to treat the terms of service as promises that they would never see content that was listed as a negative behavioral covenant. So the contract would say, don't misgender or dead name or something to that effect. And then if there was that kind of content, the plaintiff would sue and say, you promised there would be no such thing, to which the defense would say, no, we told our users not to say such things, but we never made a promise that it would never occur. The second main category was that in order to read the contract, you have to read the whole thing. And so if the terms of service apply, there's going to be something in those terms of service that says we can do whatever we want and we make no promises about anything. And so the plaintiffs would try and cherry pick off little parts of the contract and say, well, I'm holding you to this part and let's only talk about that. And then the defense is like, well, there's this other part that says we made no promises about anything. And then the court says, well, you know, if you're going to invoke the contract, we got to read the whole thing. We look to the four corners of the contract, and it's not just a cherry pick part. And the third thing, and this is one that actually would actually catch many people by surprise. We saw a few cases, including the Murphy versus Twitter case that Jess mentioned, where the court said that Section 230 preempted the contract claim. Now, this catches a lot of people by surprise, because if you're drafting a contract claim, you should be responsible for the words you put into your contract. Or if you're making false marketing representations that are false, you should be accountable for the words that you chose in your marketing representations. But courts have gotten savvy to the fact that many times this is just intended to be a blanket workaround of Section 230. It's saying, I actually am not really still in the contract. I'm going to use it as a MacGuffin to try to get at the fact that I want to hold you accountable for third-party content. And court says, you know, you can't do that. And when we see that, we're going to even preempt the contract claims using Section 230. So that Section 230 was not a majority of our cases, but there were a number of cases in which the contract claim failed because of Section 230. So the contract claims were almost never meritorious, either because they were trying to claim parts of the contract that weren't actually contract promises, or they ignored the parts and said, we're not responsible, or Section 230 applied. It was like a trifecta of ways that they failed.
So I'm going to sort of carry this on. And so I think the case you make that a full must carry common carrier regime would be disastrous strikes me as being obviously correct. I mean, why would anyone want a Facebook that is drowning in porn, for example? Because we all know porn is protected usually. But I would like both of you actually to a little bit more elaborate on this idea of viewpoint neutrality, because that seems to be, so I believe that's what Texas did. And it's sort of, I know there's a bunch of proposals, including by senators, both Rubio and Hawley separately, to require viewpoint neutral content moderation. I gather you think that's a bad idea, but I think it'd be interesting to know a little bit more about why.
Jess, I don't know if you want to take this. I definitely will take the first crack if that's okay with you.
Yeah, go for it.
So here's the problem with that. That assumes that we can establish what is a viewpoint and what isn't in a way that makes sense. And so let's just take the most obvious. Is there, what would viewpoint neutrality look like on vaccines? And the answer is there's clearly both a social view as well as I think a political view that anti-vaccines are a legitimate part of the discourse. And so in a situation like that, the internet services would be barred from being able to remove any anti-vaccine content whatsoever. And where does that stop then? Let's talk about things like, you just mentioned the Goldman case that involves an advocacy that that LGBTQ individuals could change their orientation if they just went through the proper steps. I don't think about that as a political statement, but that's not my call. But I think absolutely that would be considered to be a viewpoint in a debate that would be required to be carried. And so it's kind of like, I don't know where to stop at that point. All the things that we might consider to be hate speech or misinformation are probably viewpoints that would be foreclosed from being managed or edited whatsoever by the internet services. They're just open for all. And if that kind of content can dominate the conversation, I'm out. And once again, we just see that downward spiral. Jess, do you want to add anything on that?
Yeah, I think the only other thing I would add is, again, when it comes to, I mean, we're living in a time now where literally anything can be politicized. So, today we might not have expected that vaccine content would be political, but of course, here we are, where we see that there is actually a debate about whether the COVID vaccine works or not. Other sort of concerns that I see on the viewpoint perspective is, we don't always have all of the pieces as well. So when we're talking about misinformation, disinformation type content, the sources that that content is coming from, whether it's the government or whether it's from somebody else's perspective or a health expert, it's really hard to piece together, if that's sort of a political viewpoint or if that's, expert factual based knowledge that, belongs or doesn't belong on the service. So, I think when it comes to internet services, there's a lot of missing pieces, and it's really hard. I think Professor Goldman got at it perfectly. It's really hard to decipher, what sort of is a viewpoint and what isn't.
And if I can just add one more thing on this, to me, the entire architecture is just bizarre because it treats the most credible speaker as having equal status as the least credible speaker, and they have to be treated equally. And that can't be the right result. We can't assume that we're going to have the world's leading expert next to the person who has never spent a moment educating themselves on this topic, and we're going to say both of them have to be treated equivalently. I don't want to live in that world.
I suspect that I largely agree with you on the bottom line. And actually, as I think your paper mentions, in my contribution to this journal, I might make the argument that there's a First Amendment pretty much right of social media platforms to censor. But I want to start off by asking a question. Are we really now in a world in which it is impossible to know the difference between opinion and fact? Do vaccines work? The answer is yes, right? That's just a fact. We have overwhelming empirical data to support that. Is it your view that nevertheless the statement vaccines don't work is a viewpoint that one would have to protect?
Professor Goldman, I'm gonna let you take this one.
Sure. I don't know where we stand on this. And to me, the root of the problem is watching our government officials using our taxpayer dollars to deliberately lie to us. And so you can just line up all the people in official office working for the government who have raised in their official capacity skepticism about vaccines, or come out outright against trying to work against the widespread availability of vaccines. Think about some of the moves that the Florida governor has made as just one example, actively working against the widespread adoption of vaccines. So when our taxpayer dollars are used to fund that kind of government work, it seems like, I don't know what to say anymore. How do we fight that? Because they took our money to tell us lies to us. And now what is truth and what isn't? We have for so long in our country, but not in other countries, felt confident that if the government was telling us something, they were trying to tell us the truth, trying to establish facts. Now, certainly there are exceptions to that at every stage in our history. But I don't feel that way anymore. I feel like our government no longer really even cares about trying to tell us the truth or establish some kind of baseline set of facts that we can all use as common operation. And that structural problem seems like we're doomed. And so everything we're going to debate about on what happens when you got the crankpot on the internet who's talking about this stuff, if they're finding cover from our taxpayer funded government officials for their viewpoint, they're not the problem. Our government is.
Yeah, I hear you, of course, and of course what you're saying is correct. It's still a troubling place, right? And because it does suggest that if we really, the fact opinion sort of distinction has completely broken down in our society. All right, so let me reformulate my question as a real question rather than as a random set of thoughts. I'm going to play devil's advocate here and argue that at least one model of free speech, of public debate, or of course we call it public discourse, is an unmoderated, right? In which everyone gets, that's sort of the First Amendment model, which is everyone gets to speak, and then the people get to decide who they trust and who they don't trust. And arguably, at least, that is the model, the notion behind viewpoint neutral moderation. Is that sure, get rid of the porn because that's not a viewpoint, but otherwise, and your example, for example, of a Yahoo sitting next to the world's sort of greatest expert on a topic, what is wrong with trusting listeners to make the judgment of who to trust, as opposed to having Facebook or Twitter make that decision for us?
I think one thing I'll throw out there, and again, coming at it from sort of the issues we're seeing with content provenance today, is that we're not at a good place in our society right now when it comes to digital literacy. We have, a severe issue with folks who do not actually understand how to take in all of the sources that are coming from different perspectives and sort of, look to second opinions, avoid confirmation bias. And I think these are a lot of things, these are missing skills that, we haven't exactly, through education or through the school system, we haven't actually given the appropriate tools to folks as they are learning how to decipher this information. So I think that's one concern. I think the other concern to that is that bad actors will see that as a really easy way to sort of get their viewpoints across. We see that with the Russian troll farms around the election time of 2016. And again, when you have people that don't know how to necessarily evaluate all of the information and understand the source of that information, I'm not even talking about stuff that's, really obvious. Even the Russian troll farm related content would seem really obvious to us. I'm talking about stuff even like, manipulated media or synthetic media, where even to those of us today, we might be tricked into believing kind of what we're seeing as well. And again, for those of us who understand how to do proper research and how to consult secondary sources and how to avoid confirmation bias, those sorts of things, it doesn't affect us, but that's not usually the case for the majority of the population when they're encountering all of this information.
And I want to double down on Jess's point about digital literacy. I think that in the 90s, I had hoped that the digital natives were going to be taught how to use the internet and how to be smart consumers of the internet. And so all the transition challenges we saw about taking boomers and Gen Xers and putting them on the internet, I thought we're not going to have that problem with the millennials, Gen Z, or now Gen Alpha, because we're going to teach them in schools. We're going to make them smarter. And what we're seeing today is that we're seeing a concerted effort to actually make our education system dumber, to take away the tools that are necessary in order to teach people how to be good consumers of information. So not only will we always have a challenge about how to educate people on how to consume information, but if we handcuff ourselves in these culture wars with the efforts to try and restrict the ability to teach people to be critical thinkers for themselves, we're really screwed. So I'm more bearish about the future of digital literacy for the digital natives than I am for the Gen Xers and older. But the other thing I want to mention, you talked about how we've had this general notion of the marketplace of ideas and let everyone, let 1,000 flowers bloom, and we'll let the market decide which ones are the best. And I've been such a fan of that for a long time, and I've lost faith in it. And a lot really goes back to the earlier point I raised. When our government's lying to us, they're injecting misinformation into the ecosystem that it's extremely difficult for the marketplace of ideas to overcome. The government has so much mind share and so much visibility in what it says that it's really hard for a concerted effort to push back on that. And so the government, brings the muscle to that conversation in a way that very few other entities have. But in general, I do support the idea that the government should not be picking among viewpoints. They should not be deciding this viewpoint is legitimate, this viewpoint is illegitimate. And if you go back to the public forum doctrine, let every speaker have a corner in the park, or let every speaker have a corner on the street to espouse their views. I think that's great. Get the government out of trying to regulate that kind of content. At the same time, we have always depended upon the editorial discretion of publishers to decide what's fit for their audience. The marketplace of ideas has always assumed that there's an intermediating function of the publishers that's working to elevate the good content and downgrade the bad content. And what's so pernicious about efforts to take away the ability of internet services to enforce the house rules is it actually removes that braking system on the marketplace of ideas. And it takes away the most valuable asset that we have to actually make the marketplace of ideas work. So we need editorial discretion in order to ensure that we're going to be able to make smart choices. And so taking it away is actually just going to make us, it's going to hinder the ability of the entire marketplace of ideas function. And so, when we talk about, our Facebook or Google arbiters of truth, I feel like that question is like in a different universe than my head. My head is that Facebook and Google always have the right to decide what's fit for their audience, and they shouldn't be allowing everything to be fit for their audience, or else they won't be able to maintain their audience. So for them to treat them as like this established, wiping away the marketplace of ideas, I think grossly misapprehends what they're actually doing, which is to try to understand what their audience needs and serve it. And if they can't do that, of course, the audience won't stay.
I do want to add one more point just to Professor Goldman's point here, and he addresses this in another paper, actually, his content moderation remedies paper. When we're talking about, whether people should have the ability to choose if all content is available to them, I do want to highlight that we are moving towards a system where it's not just the content is there or the content is not there. I think that's one of the beautiful things about internet services having this ability, having editorial discretion, is that they also get to sort of pick and choose how that information, how they can best provide access to information and freedom of expression to their users without totally taking down or blocking that content. So, we see that example with Twitter, where, instead of for a lot of the, health misinformation or election integrity related questions, you'll see Twitter is flagging it as potentially being from, not a trusted source, but the user still has the opportunity to evaluate that information. They just now have sort of guardrails placed around that content too. So the information is still there for them to assess. And I'm excited about internet services sort of progressing towards that, model of content moderation, where it's not so binary as to, okay, well, we're going to decide that users can't see this, or they can only see this type of content.
That's actually helpful. I'm going to take a pause here, and I'm going to continue to ask questions, but if anyone in the audience would like to ask a question, just use the raise hand function, and I'm pretty confident as a co-host I can unmute you. So
Hey, Ash, it looked like there were a couple of good questions in the chat. I find it tough to keep up with the chat, so I haven't been able to read them, but maybe the people who are asking those questions in the chat would be willing to...
I think that would be great, yeah, because I can't keep up with the chat either. So if someone who put a question in the chat would like to actually phrase it, open it. Jane, please. And I'd like to, I am.
Okay, hi.
And I should introduce Jane Baumbauer is also an editor of the Journal of Free Speech Law, which I introduced at the beginning of the program.
Oh yeah, no, I missed the first couple of minutes, so I wasn't even here for you to introduce me. I love this work. I kind of wanted to ask a high level question, since both of you are on the line and have to answer questions from us. So, a lot of scholars, like I'm thinking Nelson Tebbe in particular, have argued that the government really needs to be much more involved in large platform companies, because the US government is the only thing that has a chance of having the power and influence over multinational, very highly, highly dominant firms. But I don't think that that's right, largely for the same reasons that Eric has already articulated, which is that puts a lot of trust that the government is some sort of stable position to be not only assessing the effect on society, but actually interested in also optimizing, the results for society. And the last few years, we see a lot of, there's just a lot of disruption, I think, in government's functioning. But it still leaves me wondering why it is that these companies have, so far at least, come up with pretty decent house rules that haven't been undermined yet, at least as far as I can tell, and as far as your data suggests. by either self-interest or some other, exploitative interest. And what makes you feel confident that that would be true in the future? Is there something about, market self-regulation, so to speak, or about the pressures that the market pressures that these firms face that make you think that this is an enduring trend? Or do you also worry about what the House rules might be in the future?
Jess, do you want to speak up on this?
Yeah, I mean, I think one point of it is competition when it comes to content moderation, and we talked a little bit about this in our paper. One of the nice things about allowing services to sort of set their own house rules is that at the end of the day, if consumers and users don't like the way that the service is handling the way that moderating the content, they can go somewhere else. They can use a different service. And we see that we saw that at least, last year with services like Twitter and then Parler and Gab. The audiences that don't like what, how the service is doing moderation will literally get up and take themselves elsewhere. So I do think, one incentive is to understand, for these services to understand who their audiences are and to try to, do the best that they can when they set those house rules and when they apply their house rules, understanding that their users can always go to a different service if they don't like the way the service is treating them.
Jane, you asked such a rich question. I bet we could have a whole panel just trying to explore all the different points that you raised. Just one thing you mentioned about how do we discipline multinational companies, and U.S. government is perhaps the most powerful entity in the world, perhaps the most powerful entity ever. And so if they can't do it, why not? But I really thought your own self-critique of that argument was really powerful. When I think about the wisdom of our Constitution assumed that our government would go rogue on its citizens. And so really, I think about the Constitution as ways to protect us as citizens from having our government abuse the fact that it takes our money and it has coercive police power, and we have no choices about that. And so, the fact that for me, I feel like so much discussion about this must carry is trying to get around constitutional guardrails that were set for the very reason that those who might exercise that power are inevitably going to go rogue on the citizens that they're supposed to serve. And I'll bring up the example of the bill that came from Klobuchar and Lujan that basically was going to deputize the Health and Human Services director to be able to designate certain categories of information as health misinformation, basically turn that into a unilateral censorship board. And many people critiqued, as would I and perhaps you, that even if I trust that person, I'm going to object to it, but I don't trust who that person is going to be in a different administration. And if that person is gone rogue on the people they're supposed to serve, we're all screwed. But we rely on the Constitution to protect us from going rogue on our citizens. In terms of the future of House rules, especially for larger companies that have a strong market position, I think I'd start with the premise that most media entities always have a temptation to go rogue on their audience. They can always look at ways to take short-term gains that are not in the audience's interest, with the possibility then that they're going to suffer long-term consequences from that. And when I think about things like where I want to have a small group discussion, if it's a handful of people, there was a time when I would say, hey, Facebook groups are great. We're all on Facebook. We should have a conversation on Facebook. I wouldn't do that anymore. I'd say, I want to take that conversation. I'm going to go have it. We have it, some of these on Signal, for example. We go to Signal and we take the exact same conversation we would have on Facebook, we put it on Signal. And so in that sense, it doesn't have to be perfect competition to help solve the problem that we have. And so as internet services decide that they're going to change the House rules from being in the audience's interest, trying to protect the audience from things that they don't want to be exposed to being a weaponized tool for the media enterprise to go rogue on its readers or rogue on its audience, yes, that's going to happen. That's always inevitable with every media. company. But I think that there's checks in that system that are that I respect to keep the most egregious situations at bay. And in the end, there is a role for antitrust to play. If there is, in fact, a monopoly that's being abused or anti-competitive behavior between marketplace players, I hope that the antitrust enforcers will take care of that. And so the question is, what's left after knowing that they're going to go rogue like every enterprise does, knowing that we will take our business elsewhere to the extent that we're free to do so, and knowing that antitrust enforcers are left? I'm not sure that the layer of concern that's left after those three factors is enough for me to worry about.
So let me, I don't see any other hands for now. So so Barler is often cited as being, actually, Michael has a question. So let me, please go ahead, Michael.
Hi, my name is Michael Karanicolas. I'm the executive director of the ITLP. Yeah, I posted a little earlier in the chat. I'm fully in agreement with your points that common carriers or acquiring platforms to cleave to the contours of the First Amendment is not a good solution. I agree with your critiques of the legislation that's been floated. We had Mark Lemley on a panel here with Eugene Bullock last week, who also argued very convincingly against it. But I was wondering if the panel was interested in commenting on the more limited question of whether there is potentially a role for the courts in hashing out disputes between users and platforms on these takedowns, because I am a bit more sympathetic there, partly because I see a need for mechanisms of accountability that are external to the platforms, but also because I think that internationally, there have been cases that have been brought forward, and I think with some success, with people suing the platforms to get their content restored. And my understanding is that there haven't been the same kind of sort of catastrophic, parade of horribles out from those cases. And so I was wondering about if any of the panelists comment, first of all, on that more limited question of whether you think it is ever appropriate for the courts to get involved in adjudicating this stuff. Obviously, Section 230 is a big obstacle to that, but just structurally, whether you think that that's potentially a good idea, and your thoughts on those international developments as well.
I think, again, it will come down to, and as we've sort of seen with our paper, it'll come down to like, what are the claims? And as we've shown, I think the claims end up sort of failing on their own, either because they're flawed in their merits or because, there's constitutional protections that internet services here in the US just naturally enjoy when it comes to editorial discretion. Now, thinking beyond that, is there a place for the courts to sort of decide these issues on their own? One thing I'll point out is that I don't think the courts are as well positioned as the services when it comes to deciding whether the types of content that the services are adjudicating are making decisions on, whether that's appropriate or acceptable for the services audiences. I think it's very telling how we've seen, how regulators sort of talk about internet services today and how there seem to be a lot of sort of technological or experiential gaps in the way that they sort of present those discussions. And so I would worry about, without being presented with more or without understanding how the service works or how the audience sort of works, I'm not sure that a court would be as well positioned as the services who engage with their house rules, every day would sort of be positioned. And I will also point out, speaking to sort of the international developments, I'm not sure if it's catastrophic, but what I will point out is that we have seen some sort of different consequences that I don't think US users would be particularly satisfied with if it were to be the result here in the US. So, for example, take what's going on in Australia. We've got users now who, as a result of a court decision, who now can be held liable for the sort of posts that, their friends or others place under their content. They can be liable for defamation claims arising out of claims that they never created, or rising out of content they never posted. I think that would be quite a catastrophic event catastrophic result for here in the US if we had to worry about all the content that we share and engage with, we could now, content that we didn't create, we can now potentially be liable for. I think that would shut down a lot of the ways in which we engage with each other on the internet. And then, one other point that I've made before is that Section 230 doesn't exist, outside of sort of the US marketplace. And so we can actually look at sort of what are the results of different markets that have sort of these different intermediary liability frameworks. We can look to, the EU and the right to be forgotten. And in those cases, you're seeing a lot of content being taken down off of services. Usually that has to do with sort of news reporting, or, as Ash was talking about, the difference between opinion and fact. Well, we're seeing fact being taken down from, these services, because either they, it's under their right to privacy, or, there's some other sort of way in which these users are able to get that content sort of removed. So I think we're seeing sort of, I believe it's been described as like a splinter net, or gaps in different markets where content is fully available, or access to information is fully available in one market, but that's not the case in other markets.
I'm going to supplement Jess's remarks, but they were all great. She covered a lot of the key points. On the question about what are the rules of the courts in intervening in account termination or content ranking disputes, to the extent that the question is what's fit for the publisher's audience, I see no role whatsoever. And I honestly don't understand why it would even be controversial. We certainly wouldn't expect that in the context of, say, a newspaper, for a judge to come in and say, you really should have published that article that you chose not to publish. That's such an offense on our free speech norms, and it's just terrible policy. But the place where it could come up, and I think some of this has been kind of lost in history. For example, if there's money at stake, then I think that the situation becomes a little bit more complicated. So, for example, two of the cases that were irresolute in our data set involved Second Life taking back assets in their virtual world that had real financial consequences for the people who had putatively owned that asset. And so in a situation like that, we could imagine that if there's money at stake that's not being handled fairly, then I think that's going to be something that's going to be appropriate for courts to weigh in on, but not on the question of whether or not it's fit for the audience. But now we've got kind of an economic right at stake where we have to protect the economic interests of the players. As for the international piece, as Jess pointed out, the other countries don't have the First Amendment. The other countries don't have Section 230. And so they're just different. Everything about them is different. And really, the regulators that have found the must-carry rules are setting up the internet services for no-win situations, because they're also at the same time demanding greater removal content that would be permitted here in the United States. And so internet services are expected to navigate this extremely fine line. Remove all this terrible content, but don't remove the good content, and make sure you get exactly as we as the regulators want. It's a no-win situation for the internet services. They cannot comply with those rules and sustain a business. And of course, as we know, then in the international environment, it has become a sport of kings. Only the richest players can survive in those markets. And so we don't see the kind of dynamism, the kind of activity below the GAFA level that we have here in the United States. And so many of us use services that are not one of the big 4 or 5 here in the United States on a regular basis, and expect and assume that we're going to be able to enjoy the conversations that take place there. And many of those services just don't exist, or are managed in a completely different manner in other countries. So what we're seeing in the other countries is a move towards professionally produced content. The rules for user-generated content have become so onerous that we're seeing the slippage of that and the rise of the professionally produced content as a partial replacement. And that's just a preview of what we're going to get here in the United States. And if we aren't going to be vigilant about it, our future is actually going to look a lot like theirs, and that's not a future I was hoping for.
All right, we are actually at our hour. So unless there is anyone else in the audience that would like to ask a question, I think I'm going to call this closed. Michael, do you have another question? Or?
Sorry, no, that is an old pen.
Okay, that's fine. Okay, well then, thank you, Eric, and thank you, Jess, for a great paper and a great conversation. And thank you to everyone who helped organize this, including Alexandra and Michael and Jane. This was great and really educational. And I look forward to carrying the conversation forward in the future.
And if I can add, I just want to say thank you to the Journal of Free Speech Law, as well as the UCLA and Arizona programs for sponsoring this. It's been such a great opportunity for us to put this paper together and share it with the world. So we're really appreciative of that. And of course, thank you, Ash, for helping spur today's conversation.
Thank you.
Likewise, thank you so much.